So we are going to start our third and last panel. And I will tell you that I'm very excited about this because I feel like this is going to be like really a very nuts and bolts, really practical session that I think you guys are going to enjoy. I'm going to turn it over to Melinda, and maybe Melinda can introduce the panel and the panelists can introduce themselves. Thanks.
Okay, thanks. Hi, everyone. I'm Melinda Maher. I'm from Dorsey and Whitney, and we're going to get started on working with insurers and TPAs. And I am as excited as Liz because I have really two amazing panelists with me who have worked in the insurance and TPA industry for a really long time, some longer than others, I guess. But I think between the three of us, we have like decades of experience with this. So I'm going to turn it over to them to say a little bit more about themselves. This is Deb Shoemaker on my left and Nadia Martyn on my right. Deb from PreferredOne, Nadia from Delta Dental of Minnesota. Deb, can you say a little bit more about yourself?
Yes, I have to get my name tag, though, upright. I'm not Shoemaker Deb, I'm Deborah Shoemaker. Good morning, everyone, and thank you, Melinda and Dorsey, for inviting me to be here today. I am an attorney. I've practiced my whole life in the state of Minnesota, and I've been with PreferredOne for almost 19 years. Before that, I was with United Health Group for about 10, private practice, and I got my start at a tax firm, at a CPA firm. My background is employee benefits broadly, but more narrowly focused in the healthcare industry and things that go with healthcare. Dental, COBRA, HSAs, HRAs, those type of things. That's where my focus has been. At United Health Group, I did more mergers and acquisitions, and I got my career start in taxation under the Affordable Care Act. Having a background in tax, because so much of it is tax related, has been a helpful experience.
So, and Deb and I had the great pleasure of working with Deb in-house at PreferredOne, and I've also worked with Nadia. So Nadia, can you tell us a little bit about yourself?
Sure. Thanks, Melinda. Thanks for having me today. My name is Nadia Martyn. I actually started my career right here at Dorsey in the health law department, so always nice to be back and see a lot of familiar faces. When I was in the health department, I worked on a lot of different matters, including some support for insurance companies. And then I had the opportunity to move in-house to Delta Dental of Minnesota, going on 4 years ago now. So now I get to work with Melinda as a client, which is wonderful to still use her expertise. And my practice at Delta Dental focuses on our insurance and our third-party administration business. We are primarily dental with a little bit of ancillary, and we'll talk a little bit more about that in a bit. But I also serve as our enterprise privacy officer. I happened to be an associate at the time when the HIPAA final rule came down, and somebody had to learn it, and that person was me. And so that privacy background has really followed me through my career. So I wear a couple hats, but I'm really happy to be here today, excited about the panel.
So thanks, you guys. So let me set the ground rules a little bit. So Nadia and Deb are kind enough to be here really in their individual capacities as lawyers who have practiced a long time in this area, but they are not really speaking for their organizations at this point. So I just want to point that out to you guys. So anything that we say is not to be construed as legal advice to you. Although if you're my client, you can take what I say as legal advice. Also, this is not to be an airing of grievances, because I know these two organizations cover a lot of Twin Cities employers, a lot of employers here. So I would prefer it if you would not necessarily bring up issues specific to yourself and ask about them. If we could keep the questions more general, I would really appreciate it, more applicable to everyone. I personally would appreciate it, and I know Deb and Nadia would appreciate that too. But we welcome questions as we go, so please feel free to jump in, because I think it always makes the topic more interesting. But I do want to also let you know, I want to level set with respect to our slides and our agenda, because I think I may have been a little ambitious with respect to the slides. So we're going to try to get through, I'm going to have these two talk about the structures of their organizations, because I think that's something that gets lost and a lot of employers don't know about it. So we're going to talk about that. I'm going to talk a little bit about self-funded versus insured plans and what goes into that. And Deb and Nadia are going to opine on that. And then we're also going to talk about contracts, because that's a huge issue, I think, in this area. Talk about plan documents, talk about networks. If I can get through all of that, I will be happy. And then we have some topics at the end that we may or may not get to. So I want to set your expectations accordingly. But please, like I said, jump in with questions. So I'll start by asking Deb and Nadia to talk a little bit about the structures of their organizations, and because they are both each an insurer and a third-party administrator. So Deb, can you talk a little bit about PreferredOne structure?
Sure, happy to do that. So PreferredOne is a Minnesota-based company. We've been operating in Minnesota for over 30 years. We are part of the Fairview Health Services system and their affiliation with mHealth. We have three separate companies at PreferredOne: a TPA, a company who's licensed as a TPA, an insurance company, and that also does stop loss, as well as an HMO. PreferredOne operates primarily in Minnesota. We do have a TPA license in over 30 other states. We also are licensed to sell stop loss in 5 other states. Primary insurance is really limited to the Minnesota market. We are a TPA that offers a full suite of complementary services that go with core health care. So we administer health plans, dental plans, fully insured for dental plans. We also administer the flex accounts that go with a cafeteria plan, the dependent care account, the health spending account. We administer COBRA and short-term disability income protection.
Thanks, Deb. And I think one of the things to keep in mind as an employer is, so when you go to an organization like this, depending on what service you're signing up for, your contract might be with various different entities. Is that a fair statement, Deb?
Yes.
Okay. So Nadia, can you talk about Delta Dental for us?
Sure. So Delta Dental of Minnesota, it's our 50th anniversary this year. So we have been a dental insurance company in the state for half a century, and we are also a licensed insurance company in North Dakota. So Delta Dental of Minnesota sells fully insured products in Minnesota and North Dakota. We also have a management services agreement that allows us to sell fully insured business in Nebraska. So we have 3 jurisdictions where we're a fully regulated licensed insurance company. And we also are a third-party administrator for many self-insured plans who have members across the country. How that works is a little unique. We have a relationship with something called the Delta Dental Plans Association. If you're familiar with the Blue Cross Blue Shield model, where there's a licensor nationally and then individual insurance companies in different states, that's similar to how our brand works. So there are 38 member companies across the country. Each member company is responsible really for the provider network in their territory. Again, for us, that would be Minnesota, North Dakota, Nebraska. And then we share that network across the country so we can administer for employers who have employees in all 50 states. And that's how we sell that business. Now, we are also, because of that, we are limited to selling for employers who are situs in Minnesota and North Dakota and Nebraska. And the other Delta Dental member companies sell to those self-insured employers in different states.
Thank you. That's very helpful. And maybe you guys could talk a little bit about the various percentages of your business that is insured versus self-funded.
Sure. So at the PreferredOne companies, more than 70%, roughly around 75% of our business is TPA focused. And the remainder is fully insured. That doesn't account for the stop loss fully insured equation, because that's usually a companion product to the self-insured market. So we're 3/4 TPA self-insurance, about 1/4 fully insured.
Thanks. Nadia?
Yep, and we're pretty similar on numbers. One thing that I forgot to mention in my overview is that we also have a vision product, but that's a very small piece of our business. Same states and jurisdictions, just a smaller piece of that.
Okay, thanks. That's helpful. So let's just talk for a minute about self-insured versus fully insured dental and health plans. And usually that starts with the primary distinction is the risk, the financial risk. The financial risk with a fully insured product, to probably state the obvious, remains with the carrier. For the self-funded products, the employer is keeping that risk, may cede that risk off to a stop-loss carrier in some cases. that stop loss carrier may be associated with the TPA or maybe a third-party TPA. Deb, do you guys allow employers to have a stop loss carrier that is not you?
Yes.
Okay.
So when we are a TPA that's retained by an employer plan sponsor, they often have a stop loss carrier they've worked with in the past. They might be having run out with that stop loss carrier. They might keep that stop loss carrier and working with PreferredOne. We also offer a companion stop loss product in Minnesota and 4 other states. And so there's lots of flexibility as to how that comes about.
And as I'm going through, let me just say this. These slides I created myself. So Deb and Nadia have no responsibility for any mistakes in here. Because the one thing I should point out, and Deb did point this out to me, is, for example, even in the insured area, there is still employee cost sharing. So when I talk about the risk, there is the employee has his or her cost share. There is the premium payment, and then the remainder of the risk would go to the insurer. And then in the self-funded world, it's similar, except the remainder of the risk stays with either the employer or goes to the stop-loss carrier, depending on how that's designed. So I just wanted to make sure that we're clear on that. The other thing I should caveat is when I talk about self-insured plans in this context or in any of the contexts that we're going to walk through, I am talking about a single private employer plan. So don't forget that there is the possibility to be a self-insured plan, but not subject to ERISA. And that would be, say, if you're a public employer or if you're a multi-employer plan. So don't forget that piece. And we will talk a little bit about MIWAs. So I want to talk a little bit about what the considerations are to be self-insured. From my perspective, and I've listed some of those considerations here, what I see primarily is size. Like if you're an employer with a lot of employees, typically you look to self-insure. Also, this is my own experience, and I could be wrong on this, but location also drives this. So if your workforce, if you are a big employer, but you might be situs just in a particular state, I would say it's probably easier to be a fully insured plan in that instance. But if you are spread across the United States, it's harder, I think, to be fully insured, and you would look to self-insurance. And I've also listed the other kind of aspects of analyzing whether to be self-insured or fully insured. And I think my question for Deb and Nadia is that something you guys get involved in? If a group comes to you and they're not sure, is that something that the TPA would normally and the insurer would normally get involved in?
Yeah, I can speak to that. If the employer has not been self-insured in the past and they're accustomed to fully insure, it's really advisable that they do financial modeling, financial projections, not just for 1 year, but into the future. Do they have the appetite for that? What is their workforce demographics? Does their workforce fluctuate, not only in size, but who's hired? And so fluctuations in your workforce often factor into whether or not you want to be self-insured or fully insured. In today's Minnesota market, fully insured small group versus large group size is still 50 and below is small group, 50 and above, 51 and above is large group. The benefits differ depending on whether or not you're a small group and large group, and your obligations and your mandates might differ. And so if your group fluctuates from going under and over, fully insured is probably the best environment you want to be in. But if you're over 51, you consider self-insurance. And as Melinda mentioned, multi-state workforce and work demographics often yields best to self-insurance if you have the appetite for the risk of self-insuring your benefits with or without stop loss.
Thanks. And Nadia, do you guys get involved in dental's a little different,
It's a little different, yeah. I think the critical difference for us, I mean, a lot of what Deb said is applicable to dental as well, especially as you're talking about size and location of workforce. We certainly deal with those issues. But the financial status and the financial risk is lower in dental, frankly. A lot of the plans, have an annual limit of $1,000, $1,500, $2,000. Even if you get into $3,000 or $4,000, you still have that cap. where you don't have this sort of catastrophic loss that you might have on the medical side. But nevertheless, our clients do ask us to help them think about what it would look like to be self-insured versus sticking with fully insured. We get into it mostly with those groups that are right on the borderline of size. That's the biggest thing. And oftentimes in the bidding process, sometimes they'll ask for both a fully insured and a self-insured quote, and it sometimes becomes quite obvious as they work with their broker that the financial modeling just does not work, even in the dental space, for a group. And then again, the location absolutely is the biggest thing too for us, especially being limited in where we have our insurance licensing, and our groups appreciate and understand that too.
And of course, you don't have the stop loss in the dental world because of the lower limits. But do you see, like in the self-funded space, the bigger employers or the self-funded employers going up in terms of limits beyond what the normal insured products offer?
Oh yeah, absolutely. So that's one of the nice creative pieces of plan design that we can work with on our self-funded groups. So it's becoming a trend to have higher limits or do things like remove a limitation on like your diagnostics and preventives. We want people to go get their teeth cleaned. We want them to go in for exams and x-rays. And so just completely removing any limits on that with the understanding that we can do the modeling and projections, but you're not going to get too high in a year. Even if you went in for, 4 cleanings, it's still not going to put you over the edge of considering whether or not you want to be self-funded. So our bigger employers, our employers who are going to the self-insured side do have more flexibility in their benefit design and are putting more money into their dental plan. There hasn't been too much discussion with some rare exceptions of really high cost services because many of those would run through the medical plan.
Okay.
Linda, can I add an extra remark? Is the consideration between fully insured and self-insured also has to be recognize the HIPAA obligations for privacy. If you are going to be self-insured, you are in control of the covered entity called the health plan. That's a big undertaking to become self-insured. Do you have the infrastructure? Do you have the controls? Have you adopted a good privacy notice? Do you have a team that has that firewall segregation? Are you prepared really to walk the HIPAA walk? Self-insurance, I can't underscore the importance of the privacy component of being self-insured. It's mitigated when you go into the fully insured environment because you are somewhat detached from the claims adjudication, claims processing, and appeal process. But self-insurance does inherently bring with it the HIPAA obligations and the infrastructure associated with that.
I think that's an excellent point, and I did make that point on the bottom of the slide. And that kind of also segues to our next slide. But before I go there, don't forget that state law applies to insured plans, whereas if you have a self-funded ERISA plan, state law does not apply. So that is also a critical distinction.
Can I say something, Melinda?
Yeah.
Okay, so I can't talk about HIPAA. I just can't help myself. Okay, I have to say something. So I think that this is a really critical point. Honestly, in practice, how this happens is the group goes through in the bidding process, or if they're going out for renewal, they want to switch. All of these conversations happen with their broker, with their account manager. They're thinking about things like risk and finances and not so much about compliance, and understanding that if you go self-insured, you are taking on more of that compliance responsibility and burden as the employer. And so I see it happen where we have groups that switch over and are totally surprised by the additional obligations that they've taken on. And it could be a situation where, it's their broker doing it, and then it's somebody else completely in the company who's now saddled with the additional responsibility. And so I implore you, if you have a seat at the table in deciding what type of plan you want to be, think about this, because this can be not only time-consuming and regulatory heavy, it can be there's cost associated with compliance and creating a privacy program. You need legal advice, and how do you administer an ERISA plan? All of these things that you would take on as the employer on a higher level, as if you go self-insured, that I think a lot of customers might not think about when they're choosing. It just sort of comes after the fact.
Yeah, I think that's an excellent point. So let's talk about, so having that in mind, we have the HIPAA issue in mind, but also let's have in mind just the overlay of state law. State and federal law will dictate your benefits in the insured world, whereas it will not in the self-funded single employer ERISA world. So that's a critical distinction, I think, too, that we see. And does, I think, a lot of times employers like that. They love the idea of we get more flexibility with our eligibility and our benefits, which they can get in the self-funded space. And I think you guys, you do get involved, I think it's fair to say, in designing plans, both obviously on the insured side, meeting all of the mandates that they have to meet, but then for the employers. Is that true, Deb? Can you speak to that a little bit? Like, what is your role there?
In the fully insured space, the benefit design is often dictated, at least at the threshold level, by the mandates, both federal mandates for preventive, emergency services at a non-network provider and the like. But at the state level, particularly in the state of Minnesota, Minnesota is considered to be a very regulatory robust and a mandate robust state. If you didn't know that, it is. It's more prevalent of mandates than other states. The essential health benefits defined set is defined for us in the state of Minnesota. That came with the Affordable Care Act. And so at a minimum threshold, you need to have those floor benefits, floor mandates in your in fully insured designs. Employers can add more enhanced benefits. Obviously, most insurers, including PreferredOne, adjust your premium if you go beyond those mandates. Most people find the mandates in Minnesota to be quite adequate and essential, but you can always go up. And so in the insured space, the benefits are more structured for you due to state mandates. And the mandates differ by small employer versus large employer. And it didn't define large and small by virtue of 50 to 51. Some mandates kick in at 100 lives. So Minnesota has 3 tranches of size for mandates: 0 to 51, 51 and above, 100 and above. And so Minnesota has parsed it out 3 times.
And Nadia, can you speak to, I mean, the dental space is a little different. It definitely still the state mandates, maybe less so.
Yep.
Yeah.
Absolutely. Everything Deb said, I 100% agree with. And dental does have a little bit less on the specificity of what the state mandates require, although pediatric dental is an essential health benefit. But on the self-insured side, we absolutely get involved with our customers in designing creative solutions to what they believe their employees' needs are. And everything that is talked about on the medical side, insofar as wellness and additional, fluoride for kids, additional preventive services, overall health, are discussions that we're having. And I think that it's one of the, could be considered a benefit to being in a self-insured plan, is to have a little bit more of that flexibility and creativity in designing a plan that complements the medical for the employer.
Yeah, and I should point out, I feel like there's a lot of innovation actually in the dental space because of the research that shows the strong connection between your physical and oral health.
Yes.
I know you guys have done a lot of work on that, so I think that's really interesting. And I don't know that we're going to get there. That's the last slide, but I just wanted to point that out. So moving on to contracts. This I think is always an issue for my clients working with TPAs and insurers, also for my clients who are TPAs and insurers working with employers. This is an area where we interact quite a bit, the employer and the TPA or the insurer. So I think it'd be worth just talking about the difference, for example, between the insured and the self-funded world here. For one thing, for the insured plans, those contracts are filed. Any of you who have worked with insured plans have heard that before. We cannot change this contract because it is filed. In the self-funded world, it is not typically filed, particularly for your single employer ERISA plan. Contracts are not going to be filed with the state. So I think I'll ask you guys, because I'm always a little curious. Some carriers require a countersignature, some don't. It's effectively a policy. Deb, can you speak to kind of what you guys do with your insured plans and your self-funded plans in the contract space?
Yeah, thank you. So in the fully insured space, Minnesota has really changed a lot of its insurance policy construct and contracting since the introduction of the Affordable Care Act, when it became full-fledged in 2014. Our ability to have variable language approved has been limited and is more confined. We really have to file contracts with no variability if you are a small employer, and we're allowed some variability, a lot of it in the eligibility space, not so much in the benefit space, other than numbers can shift and slight variation for the larger employer space at 51 and above. And so in the state of Minnesota, our company files contracts that are pro forma. They are filed exactly as they will be issued. In the small group space, every number is filled in, no variation on numbers. Every separate number is a different contract filed and approved with the state of Minnesota. You actually can see it. It's on file at Department of Commerce, Department of Health. It's also filed with HIO CMS. It's available through federal websites as well. No variation in that design. We don't ask for countersignature. It's a filed contract. We get to fill in one line, and that's the name of the employer and the premium rates that's been coded and secured and are guaranteed, as well as guaranteed renewable. And so we are not requiring a countersignature other than the client's name, customer's purchaser name, policyholder's name is entered on something called the Group Master Contract. That is the contract issued to the employer. A certificate of coverage document, the evidence of coverage itself, is issued to the members, the underlying individuals who are participating or enrolled for coverage.
And Deb, do you issue a new one each year, or does that kind of depend?
So in Minnesota, we either have to restate the whole contract year in and year out, each fiscal renewal date. They don't have to be renewed on the calendar year. Many clients are fiscal year operating clients. They have a 7/1 renewal date, a 10/1, 11/1, or 12/1, and I meant those are the calendar months I'm referring to. Some do have January 1. And so when we issue that, our state of Minnesota prefers a full new renewable contract issued rather than amendments renewing the contract. Minnesota has migrated away from an amendment format and prefers not to have that. It's a full-fledged contract each year.
Okay, thank you. And Nadia, you guys too have policies, obviously, that you issue?
Yeah, ours we're a little bit different in dental land, I guess. We don't issue on the calendar year necessarily. Same thing, we would issue at the direction of the client and what their choices for their maybe it's a fiscal year, or it's a school district that has a 9/1, 10/1, 7/1 date, something like that. And we do issue multi-year contracts, and we do require a counter signature on our fully insured contracts. It has been a subject of discussion, I think, because this is just a place where sometimes the contract gets lost in the excitement of buying a new plan, I think. It's never lost on us. We love contracts. But I think these are the same thing as Deb. We file these with the state. It's heavily regulated. We go back and forth with the state to ensure that what's in there is what's required by the state. I think one thing, just to underscore what Melinda said, is sometimes we get in an awkward conversation about a client's desire to amend or change or fix or whatever, some of the language in that contract. And it puts us in a tough position because if it's a filed product, there's not much that we can do. And again, when you're thinking about what type of plan you want for your employees, remember that the insured plans are pretty strict in their terms, like pro forma contract, I think was the term that Deb used. So it's not that we as the insurance company are being obstinate in our refusal to let you change the contract. We don't often have a choice when it comes to an insured plan.
Yeah, I think that's great. And actually, Deb, you mentioned something I wanted to just elaborate or have you elaborate on. Yeah. You talked about filing with the Department of Health and Department of Commerce. Can you just speak a little bit to why you would file with one or the other?
Sure. So we have two agencies in the state of Minnesota that predominantly regulate the insurance/HMO industry. Minnesota Department of Commerce has jurisdiction over HMOs as well as Minnesota Service Corporations, the Blue Cross Blue Shield type structure. And then Minnesota Department of Health has jurisdiction over Minnesota licensed HMOs, whether they be for-profit or nonprofit. You file your contracts and your benefit documents with that applicable entity, depending on what license you hold. The PreferredOne companies has one of each. We have dual regulators we interface with. Some of the mandates we have to deal with are universal to both of those products. There used to be a time in Minnesota where the two regulators did not interpret the same mandate the same way. Imagine that. We had two different results. I would say that our regulatory structure after the Affordable Care Act, the regulator bodies in Minnesota and the two agencies have gotten to be way more consistent and alike in their thinking, and there's a lot more uniformity between the product designs.
So, and you'll see at the bottom of this slide, I talk about a typical problem, which I see all the time, which is contracts not getting signed. And I would say that's typical in the self-funded plan world. So they either don't get signed at all, or probably more typically they get signed a long time after the effective date of the contract. And I have to tell you, I've worked in this world for, I won't say how long, but I thought that that was kind of normal. And then I started, some of my clients are like, what is it, why are we not having a contract signed ahead of the services being performed? And I did start to think, yeah, you're right, that isn't how it should be. But for some reason, this is how, it is pretty common. And where I see it normally become a problem is when there is a problem. Then you go pull your contract out and you have an issue because you don't have a signed contract, you being the employer, or it could be the vendor. And where I've actually seen it play out is in run out. So sometimes when you are planning to leave, you will pull out your contract and it is not signed and you cannot get the vendor will not provide run out. So that's one area where I've seen implications. I don't know if Deb or Nadia, if you guys can speak to that. Have you seen this as a problem?
Yes. And I'm going to take a step back and think about the holistic relationship between the plan sponsor in the self-insured context. For us, we don't have issues in the fully insured because there's no countersigner. So I'm probably more speaking about the self-insured market. And I want to toss a question to the group. If you have been in the self-insurance market or you're contemplating it, and you have an unsigned original contract with your TPA, I'm going to call your attention to one really critical issue. When you are hiring your TPA and you are acting on behalf of the covered entity, that is a HIPAA privacy relationship. It behooves you to have a good business associate agreement with that vendor. And that business associate agreement describes the role of that vendor, how they can use your data, when they may redisclose it or not, and the uses and limitations you've placed on them. It's often defined by reference to the very service agreement that describes the scope of services. Are they doing the appeals? Are you? Are they doing the first appeal, the second? Are they doing other services for you? If you want a good, strong obligation and good governance and good compliance, you want that BAA, Business Associate Agreement, entered into before you exchange any enrollment or PHI with them. But the BAA is only so good as the service agreement it's linked to. If there is no service agreement, you have left yourself, and we as a TPA don't want to leave it to guesswork. What is the scope of services you're authorizing them to use that data for? And when may they redisclose it? So there's a mutual interest in making sure you have the BAA signed and the linked service agreement to which it relates. The two documents have to work hand in hand. You really don't need, you shouldn't have one without the other. So I'm trying to make the pitch. Think about doing good compliance by having a good, sound BAA and the ASA or service agreement that goes hand in hand with it.
I think that's an excellent point. Nadia, do you have anything to add?
Yeah, I mean, we have the same issue with having our contracts signed, maybe not as timely as we would love. I think that for us, when it comes up as an issue is when we get into a contract negotiation, this could be part of the reason why it takes a while to sign sometimes, and the scope of services changes in some way. So we have what we have our sort of template administrative services agreement, but if the customer on a self-funded basis wants something a little different, they want something a little more, they want a performance guarantee, they want us to print all their SBDs on really expensive paper. I just made that up. But then you start saying, well, hold up. When we went through the pricing process and when we negotiated this at the bidding time, this wasn't really part of our discussion. And that's where we get into, can we do that? Do we want to? Is there a price change? And then you start going down this road, and it takes a really long time to negotiate that. And so part of, I guess, if I'm going to put in a plug, always happy to plug HIPAA too. I would say if there are special things that you're looking for from your third-party administrator that you know in advance, that you expect in advance, if you can build those into the RFP process, that may help you get to a contract faster. Because it's really better for both parties to have a contract, to be real clear about who's responsible for what, even down to the very beginning of the relationship. Who sends out the ID cards and how fast? And who's responsible for something if that doesn't go well? Right? It's important to have those things buttoned up, but if you're still negotiating that at the time the ID cards are going out the door and something happens, then you have a problem. And so we've started to see a trend in the bidding process where we'll have customers ask for our agreement through the RFP process. So it's kind of getting a jump start on the contract in the actual negotiation, and then they can see, what am I buying? What is this administrative fee going toward? And it helps us get further down the line and have some of those conversations up front to impact both our bid and also getting the contract executed faster.
I think that's exactly right. And I actually, because we talked about this earlier, and I asked, what's the best way to solve this problem if you're the employer? And I think it is in the RFP process to either ask for the vendor's contract and have your lawyers review it, or put in, I think this has been effective when I've seen it, is actually if you have your legal department say, these are the things we want in that contract, put it in the RFP and say, this is what we want. A good example of that might be, we want the TPA to be the claims fiduciary. We want them to decide all appeals, for example. Well, that's important for the TPA to know because they may price differently as a result of that. That's just one example, but there might be others. But I don't know if you guys agree with that, but the RFP process may be a way to get at this problem.
Absolutely, and I think that it gets you, even if you don't go through the full exercise of producing a contract as part of the RFP process, you can get there by asking some questions. So if there are things that are critical importance to you when you're looking at a plan, putting them in the RFP allows you to say to the people who are bidding, hey, this is mission critical for us. If you're not going to agree to it, maybe we don't choose you. But it also says to us as the TPA, hey, this is mission critical for our customer. So if we can't do this, we need to either increase our price, take on additional compliance obligations, whatever it is, know that language is coming into the contract and we're ready for it versus being maybe surprised by it later on and then having to have this uncomfortable discussion with your brand new customer about what their expectations are because it was unclear, not by anyone's fault, just it didn't come up. Maybe we didn't think of asking it through the process.
Right, and I think even if you don't do a formal RFP process, you can maybe get these issues out front if you introduce them through your broker or your salesperson. The one point I want to make too, with respect to what Deb said, which I think is an excellent point, this idea of the BAA and the link with the service agreement. But one thing I've run into, which I think is kind of interesting, is oftentimes when you're coming into a vendor, you're actually sending data ahead of the. In fact, almost always, I think, you're sending your data ahead of your effective date of the services agreement. So don't forget that sometimes you want that BAA to be effective earlier than when the services agreement is effective, and you certainly want that BAA, you want the BAA, at a minimum, you want a BAA, I think.
Yes. Maybe you want an ASA too, but minimum the BAA.
You probably want an ASA. Okay, let's talk about plan documents because this is another area where we often interact, the employer, the TPA, and the insurer. So I'll start, I guess, with you, Deb, again. What is the process by which you, produce SPDs for your clients in the self-funded world? And then kind of talk about, kind of compliance aspects with that and also the insurance contract?
Yes, happy to do that. So in the self-insured arena, clients often drive a lot of the elements of what they want in an SPD. And when I think of a TPA organization, sometimes the client or the customer, employer, sponsor has the TPA just for one component of its overarching welfare plan structure. So maybe the TPA is only administering the medical component, and maybe others administer the dental. And so we can't expect any TPA to know the holistic approach of that employer. So it's often very important the employer is working with its advisors, its legal counsel, to make sure the construct of its whole benefit structure is captured in its legal plan documents, particularly if it's governed by ERISA. That's a mandate under ERISA to have those plan documents and disclosure obligations. And so when I think about the TPA's role, often the TPA will prepare a draft of an SPD designed to have the client's benefit constructs, attempt to cover the compliance obligations, the ERISA disclosure pages, any other disclosures. If it's a grandfathered plan, you have to have the grandfathered statement. If the client is subject to the 1557 non-discrimination notices because it receives federal assistance and federal funds, the non-English languages, you have to have that posting. But we always say as a TPA, this is a draft. These are not legal documents. They are draft documents. Confer with your counsel, have them with your outside advisors review them, and then adopt them if you believe that they are accurate and complete for your needs. And they might not be the only benefit plan you have under that construct. It might be a subset of many other benefit plans. In the fully insured world, our company does not prepare SPDs. You have an obligation if you're an ERISA employer to have an SPD. Hopefully you have a construct and you work with your outside advisors. We just do the bare minimum mandated by the state of Minnesota to issue you insurance policies and certificates. At PreferredOne, they are not SPDs. They don't meet ERISA. You have to do something else to put it into the ERISA construct with your ERISA obligations wrapped around it.
And that's just with respect to your insured plans?
Yes.
Yeah. So Nadia, can you speak to
Yeah, we do almost the same process, particularly with respect to our self-insured plans. I think what's interesting from our perspective in dental is with the rise of sort of the wrap concept and employers wanting to have a wrap around their whole benefit structure, we only administer dental and sometimes vision, so we really don't have the view into what they're doing for medical, and more employers are moving to just taking what we give them and putting them into their wrap versus having a totally standalone dental SPD. So like Deb, we do produce a document that includes the ERISA compliance components for our customers, with the caveat that it's their responsibility to ensure that the document itself is an ERISA compliant plan document, but seeing more often that groups are taking just the sort of benefits and appeals section related to dental and putting it in their wrap, which we will get it back on a full copy of it. But it's interesting because it speaks to your point of we don't see the full picture of it often. As the dental administrator, we have our piece, and more employers are communicating to their employees in kind of this more holistic way through a very special kind of wrap document that's very foreign to what we normally produce. So that has been a huge trend I've seen in the last probably 2 to 3 years, even since I started, where employers are moving away from having that completely standalone dental document.
Yeah, and I think having worked on both sides of this transaction, I've been on the employer side, I've been on the TPA carrier side, I think what I would say to employers is what I see, because these two have to meet the needs of a variety of different clients, from the smaller group, less sophisticated groups on up to the giant, very sophisticated groups. So they are meeting needs all along that spectrum. And you guys don't have to agree or disagree with this, but I do think that they make every effort to get their documents to a place that everybody on that spectrum can use. And I have to say, I've seen it. They work very hard on their documents so that they're good, and they have in them mostly what you are going to need as an employer, with the exception maybe of some of the ERISA stuff. So they have that. They are working on that, and they have that in mind. But ultimately, I think what they would say is, that the ultimate responsibility has to be on the employer plan sponsor with respect to ERISA compliance and other compliance. And I think that's a fair statement. I don't know if you guys want to jump in. No.
I would agree.
The one other thing I didn't mention that I want to talk about is distribution, because we've had some negotiations with customers about this, and as you know, the rise of electronic, intranet sites and email, et cetera, has been an interesting thing for us. So we have a full gamut of distribution methods, from some groups who we mail the plan document directly to the member's home, to us shipping a box of them to the employer for distribution, to us sending one electronic version that the employer then distributes, in whatever way they deem, a valid distribution and compliant distribution. I think some mail, some email, some post on an intranet site. So that's one thing to think about when we're talking about contract negotiations as well, because that happens really early in the process of onboarding into a new plan. And we have had a wide variety of reactions to the distribution question based on the sophistication of the client, size, need, volume. Certainly mailing a thick plan document to hundreds or even thousands of people can be quite costly. So it's not really our preferred method, especially now that there are other forms of distribution, methods of distribution. So just something to sort of think about when you're working with plan administrators. How are you going to get this document in people's hands, and are they going to help you with it?
I think that's great. So let's move to networks and do a quick discussion of that, and then we'll open it up for questions. We'll hopefully have time. So let's talk about networks. Let's understand networks and how they work. And I'm going to kick that off with you, Nadia, because I know you guys have a somewhat unique network structure.
Yeah, so we have multiple networks that we consider to be in-network. Our two biggest nationally are the Delta Dental Premier and Delta Dental PPO. And our plan design is actually built around those two networks. So you may have a different level of benefit, different level of coinsurance, depending on which network you go to. So both, maybe Premier and PPO are both in network for your plan, but you pay more at one than the other, or you get a little bit more on your maximum at one than the other. So it's important, that's an important distinction for people to understand when they're buying plans and when they're choosing plans, because that can be a little confusing. It's more than just, are you in network, are you out of network? For us too, the biggest difference in feel for our group and our members is we don't pay out-of-network dentists directly. So if you're an in-network dentist, we'll mail the check right to the dentist. If you're out-of-network, the check goes to the member with the expectation that they pay the dentist. We have a very robust network, so this hopefully is less of an issue for most, but it does happen, and it can be confusing because it's often different than what a medical carrier might do, and so people can sometimes be confused as to why they're getting a check in the mail, but we try to make that pretty clear, and it's an important piece when you're picking a plan design. We work with our customers to say, here's how many of this type of dentists in this network are in your area. If you have a plant in a particular area, we'll do geomaps to show you kind of what dentists we have in your area that can help see your members.
Okay, that's helpful too. And can you speak to the national network idea, how that works for Delta Dental?
Yeah, absolutely. So nationally, our dentists in each individual state are contracted directly with the member company in their state. So, for example, Delta Dental of Iowa has contracts directly with dentists in Iowa. Our member, so somebody who's either a Minnesota resident or an Iowa resident working for a Minnesota company, goes to see that Iowa dentist. We have a national database that we hit up against to get their fee and pay that Iowa dentist, just like they're any other in-network provider. So we use that model to really make it seamless for if you're an employer that has employees in different states. Doesn't feel any different than if you're here in Minnesota, because you are going to have the benefit of all of our dentists across the country.
That's helpful, thanks. And Deb, can you talk about your network structure?
PreferredOne in the healthcare area, the network topic has really gone through a huge transformation. We really saw it start in 2015 with the introduction of ACOs for the Medicare space. That entered right into the commercial space by plan sponsors, both in the fully insured environment as well as self-funded. And so ACOs are accountable care networks or accountable care organizations where maybe an employer offers its employees two types of benefit designs. At point of enrollment, your workforce can decide, do you want a high-value, low-cost network opportunity, or do you want a choice broad network opportunity at time of enrollment? If you have your life event during the course of that plan year, you can if you get married, have a child, et cetera, you can swing in and out, but otherwise your enrollment election remains intact. The inverse of that is that under one single plan design, you have tiered structures, tiering of 1, 2, or 3 tiers, often network-driven, not always, but often structured around, if you use this narrow scope of networks, your cost sharing is this, your co-pay, co-insurance structure is this, and as you go outside of that, it might expand. We do offer out-of-network coverage at PreferredOne. We have to for our fully insured product, not necessarily for our HMO. Self-insured employers in this state still really love choice. Most of the employees in this state are really choice models, and choice in Minnesota is a very, very prevalent thing. I don't think choice network structures are ever going to end soon. It's a very part of the DNA, and employers do continue to offer that. When PreferredOne does administer in or out-of-network benefits, we do remit all the provider payments, in-network, out-of-network. We don't issue checks to the member itself. We issue remits directly. We do have out-of-network arrangements with Aetna, as well as Multiplan and PHCS. And we also have regional networks. We have 32 regional networks across the U.S. for unique geographic spaces an employer may have. And so I think in the network area, employers have broad footprints way more today than they did a long time ago. Most TPAs that you do business with have to have a multi-state footprint as well as a national network exposure, because I think with the increase in electronic communication and telecommuting and remote workforce, usually most employers have employees in multi-states. And you want good discounts to access those discounts for your health care coverage if you're a multi-state offering health care.
That's helpful. Thanks, you guys. Okay, so we're going to get to, we can cover at least the claims process, I would say. So this is an area, again, where it's important to have good communication between the TPA and the employer. In the insured space, typically, the employer is not going to be involved in claims. But in the self-funded space, it is possible that you as the employer ultimately would be making the decisions on your claims appeals. I have seen the trend be that employers don't want that responsibility, but maybe Deb and Nadia, maybe starting with you, Nadia, you can speak to what you're seeing in this area and kind of how it looks from your perspective.
We are almost always on the self-insured side, so it's self-funded side, delegated at least on a limited basis the claims fiduciary responsibility. So for initial claims determination and appeals, it's pretty much an expectation that we will handle those as a limited fiduciary. Sometimes we have plan designs with certain customers that they would take a second level appeal directly, and that second level appeal would go to some sort of committee they have for their plan, or a second level appeal that we would administer, but that's the rare exception, and there's almost no involvement from the employer on claims determination.
Yeah, and I would say it felt to me like maybe 10 or 20 years ago, more big employers would have their committees to consider the appeals. And I actually don't think it was a terrible structure because it gave them more insight and oversight into their plans. But I think for a variety of reasons that that kind of structure has gone by the wayside. But Deb, I don't know what you're seeing on the medical side. We
see a bit of both, and we see all of the above and everything. I will tell you that the trend for, in the fully insured environment, the insurer does usually all appeals. I've never seen any variation on that. In the self-insured environment, the demarcation that we have seen is if you are a public employer and you're a city, county, state of Minnesota, a school district, municipality, 90% of the time, if not 99, you do not handle any claims. The public sector employers segregate very strongly the demarcation between their role as plan sponsor versus their role as any type of claim administration. They really don't take that on. In the private employer space, we see all of the above, everything that Melinda has referred to and Nadia, and we see different practices. Even when the employer has delegated discretionary authority or fiduciary authority to a TPA, most employers want the right or reserve the right to take back a claim and self-adjudicate that. They put that into their ASA and into their SPD because they want their stop-loss carrier to not displace that decision should they make it and the TPA didn't. It's very, very important that your SPD clearly demarc who is making that decision. You want that stop-loss carrier not to arbitrarily question the decision maker. If you are going to make any appeal decisions or claim decisions, again, I will reiterate the need for the HIPAA privacy firewall. You can't do that unless you have that infrastructure to adhere to HIPAA. You have your firewalls, you have a privacy policy, you posted it, and you follow very carefully the segregation of those activities.
Yeah, I think that's a great point. And so what can go wrong in the claims process? When I brought this up with Deb and Nadia, they said nothing ever goes wrong in the claims process for them. So I can tell you what I've seen with other vendors, which is what can go wrong is sometimes the timing is incorrect by the vendor, or so the claim or the appeal doesn't get decided within the time frame that you would prefer or that the law might require. Also, this I think is very common. The denials leave something to be desired. So a lot of times the claim denial is a coding matter. So the EOB will go out with a claim denial. It will have a code. When it goes up on appeal, if you're the people looking at the appeal, sometimes you're like, wait, what is that? The denial doesn't quite match with what really was going on. So I would say that's a common problem. I don't think it's a problem with these two, but it might be a problem otherwise.
There is one more area that maybe has some claim issues. Employers still offer HRAs today, and sometimes HRAs sit separate from your fully insured plan, or HRAs sit separate from your self-insured plan. They aren't integrated. And there's a misbelief that your HRA isn't regulated by ERISA. No, that HRA for a private employer is truly an ERISA self-insured plan. It has to fulfill all the claim and appeal obligations that a full-fledged ERISA plan does. There's a bit of belief that the HRA is something different. It's like an account, a bank account. It's a bookkeeping account. It doesn't have any ERISA obligations. That's the number one area I think can go wrong is the HRA has the same disclosure and appeal process and notification and appeal content requirement that a normal full-fledged plan would have.
Yeah, that's a great point. So I think we are almost out of time. So I think I'm just gonna, this slide you can come talk to me about. I'll tell you what the various responsibilities are. You know, just as a rule of thumb, like reporting is going to be the employer's responsibility ultimately. COBRA often divvied up. HIPAA privacy and security, we already touched on that a little bit. Affordable Care Act, again, mostly the employer's responsibility, except in the insured world. New innovative ways to approach plans I don't think we'll have time to talk about, but I just want to touch on one issue under common problems, and that is in the M&A space. So what I see here is you acquire an entity and they come in, but and how to get them covered under your various benefit plans. Or you divest of an entity, but you want to continue those benefits, but then it becomes a MIWA. So that is something I know that the vendors struggle with because they not only struggle with the actual logistics of it, but it's also, it can be a licensing issue for them. So don't forget, you know, if you acquire an entity that is outside of their area of license, they might not be able to help you with that. I guess that's one issue I just wanted to raise. So that's all the time we have, but we could take a quick question or two if anyone has one. Otherwise, we're here after if people want to come up and ask questions. I think that's it. Thanks.
So I just wanted to echo Melinda's thanks. Thanks very much for coming, and we look forward to seeing you next year at the 5th Annual Forum. Go have a lovely rest of the day.